Hello viewers, in this video I am going to explain what is Hiba. Hiba under Muslim law. The first question comes in our mind that whether gift under Muslim law and Hiba, whether they are same. So in this video I am going to explain that what is Hiba under Muslim law, what are the essentials of Hiba, and what are the formalities according to which Hiba can be completed. So first question which comes in our mind that whether gift and hiba are they same? Answer is yes, they are same. Gift and hiba, they are same. Gift is regulated by Transfer of Property Act and hiba is regulated by personal law, Muslim personal law. So gift in India, the rules of gift in India are regulated by Transfer of Property Act. The essentials are mentioned under Transfer of Property Act. So gift is wider than hiba. Hiba is a concept. Hiba is a gift under Muslim law, and essentials and execution is according to Muslim personal law. So at the initial stage, gift and hiba are same, but gift has wider scope and hiba is regulated by Muslim personal law. So formalities as to execution of hiba are different. So in that case, hiba and gift, they are slight different on the part of execution, on the part of declaration of gift. The second question comes in our mind that is Transfer of Property Act applicable to hiba? So we just explained that no. Transfer of Property Act will not be applicable to hiba because hiba is regulated by Muslim personal law. So Transfer of Property Act will not be applicable to hiba, but for sale, mortgage or lease, yes, in that case Transfer of Property Act is applicable. The next question comes in our mind that why this exemption? That is, to some concept it is applicable and to the other transaction it is not applicable. Whether it is discriminating, whether it is violating Article 14 of the Constitution. This answer we can get in this case, that is BB Mariam versus Muhammad Isha, AIR 1963, Patna, page number 229. In this case, court held that the procedure which is applicable under Transfer of Property Act is applicable to gift but not to hiba. And what is written, what procedure is written under hiba for Muslims for the execution of hiba is not discriminating. So court held that it is constitutionally valid and it is not violating Article 14 of the Constitution. So hiba is transfer. Hiba is transferring the property. So one person is transferring the property to another person. Under Muslim law, there are two modes of distribution of property, two modes of disposition of property. One is testamentary disposition and the other is intestate succession. But hiba is a different kind of mode of distribution of property. That is, when a person is living, that is during lifetime, he can transfer the property. In will, that is wasiyat under Muslim law, there is a limitation. That is, 1/3 part of a property can be donated through will. But that restriction is not applicable to hiba under Muslim law. So hiba, difference between hiba and wasiyat is that hiba is a transfer of a property during the lifetime of the person, that is donor, and there is no restriction, there is no limitation as to transfer of property. And wasiyat, wherein the person can transfer the property through will not beyond the limit of 1/3 part of property, and will is executed after the death. So hiba is mode of transfer during the lifetime of the persons, that is donor and donee. So hiba is a transfer of property. The property which must be specific property, determinate property. So donor is transferring the property to the donee. That transfer is without any exchange, without any consideration. So hiba, that is gift, is made of a property, specific property, and that too without any exchange. Donee cannot take any benefit from the donee. Donor cannot take any benefit from the donee. So in hiba, property is transferred. The transfer is conferring the right to the donee. That means when the property is transferred, it is transferred with the ownership and possession. There is no restriction, there is no condition. So hiba is conferring the right. Right means ownership right, possessory right we are talking. So hiba is a process wherein right is conferred on the donee, and that too on the property. It is without any exchange. So transfer of ownership without any consideration is called hiba. Section 122 of Transfer of Property Act has defined the term gift. That is, gift is a transfer of certain existing, movable and immovable property made voluntarily and without any consideration by one person called donor to the another person, that is donee. So donee may accept, or on his behalf any person can accept the gift. According to the definition of hiba, the essentials are distributed in three main parts. The first essential of hiba is parties of hiba. Who are the parties of hiba? Second essential, what is the subject of hiba? That is, what will be the subject of hiba? And third, what are the formalities when hiba is executed? So these three essentials are very important for validity of hiba. The first essential, that is parties. In hiba, there are two parties, that is donor and donee. Talking about competency of donor, that is qualification of donor. We are talking hiba under Muslim law, that is why donor must be Muslim. He must be major, that means he must have attained majority, that is 18 years according to Indian Majority Act 1872. So he must have completed 18 years. He must be sound mind, that he must understand that which property and to whom he is transferring the property. So he must be sound mind, he must be major, he must be owner of a property. That means whatever property he is transferring to the donee, on that property he must have full capacity. He must be owner. There should not be any limitation on the property. The property should not be mortgaged property. The property should be free. He should have full right over the property. So donor must be owner with full right. And he must transfer the property with free consent. That means voluntarily, without any compulsion, without any force. So qualification of donor is any major person, Muslim person, sound mind person, having full right over the property, voluntarily can transfer the property to anyone. Second party in hiba is donee. Donee is a person who accepts the gift. The donee can be Muslim or he can be non-Muslim. So there is no restriction that the beneficiary, the donee who is accepting, may be Muslim person or he may be non-Muslim person. The person who is accepting may be of any age, may be minor person or may be major person. He may be male or he may be or female. So religion, creed or age is no bar in acceptance of hiba. But if the donee is minor, but if the donee is insane person, the guardian on their behalf may accept gift from the donor. The only important condition put under Muslim law is that donee must be in existence at the time of transfer of property. That means gift cannot be created to dead person, cannot be created over dead person. The donee must be in existence, maybe minor person. The last point is about unborn person. So if the child is in the womb, whether gift can be created? According to Muslim law, generally the general rule is that gift to unborn person is void. But there is one exception to this rule. That is, if the child is born within 6 months from the declaration of gift, then that gift is valid, absolutely valid. So rule is gift to unborn person is void. This is general rule. Exception is that if the donee is born within 6 months from the date of declaration of hiba, then it is valid. Next essential, second essential of hiba is subject. Subject of property, subject of hiba. That means property is a subject matter of hiba. Always property is a subject of hiba because it is a transfer of a property, transfer of a property from donor to donee, and ownership is created, possession is created. So property is subject matter of hiba. A Muslim person can donate, can transfer his entire property. That means 100% of property can be donated to donee. There is no restriction in hiba. The restriction is in will, that is not more than 1/3 part of a property. But what should be the nature of property? Whether property must be in existence, whether property must have some value, whether property should have right which is to be exercised? Answer is yes. Property must be in existence over which hiba is created. So property must be in existence. The property must be such over which right is exercised. Ownership is a right, title is a right, possession is a right, enjoyment is a right. So any property over which ownership, possession can be exercised can be subject of hiba. The property which has value, some value, goods which has some value. So any property which is transferable in nature, property which is existence, which is in existence can be subject of hiba. So tangible property, intangible property, movable, immovable, corporeal, incorporeal can be subject of hiba. Hiba can be created over corpus property as well as usufruct of that property. That means building or rent of that building. On both benefits, on both the properties, hiba can be created. The last one, that hiba cannot be created on the services. The property is the main subject of hiba. So on services, hiba cannot be created. The third essential of hiba is formalities. There are three formalities in hiba. First is declaration should be made by donor. Second essential, there should be acceptance by donee. And third essential, there must be delivery of property. First essential, that is declaration. Declaration must be made by donor. When he is declaring that he is transferring the property to donee, the intention must be clear, the statement must be clear, the intention must be bona fide. So, first formalities, declaration should be made by donor with clear intention, with bona fide intention. That declaration can be made orally or it can be made in writing. There is no requirement that gift should be made in writing. Second essential is acceptance. Donee must accept the gift. If the donee is not accepting the gift, then it is void. So acceptance is very important. The second step, acceptance by donee. So acceptance must be made by donee. When gift is accepted, then only we can say this gift is complete or it is completed on acceptance. Acceptance can be expressed or it can be implied. That means directly he is accepting or indirectly somehow by action he is giving approval. Then in that case, express acceptance is valid. There are some exception to this rule. That is, if the gift is made by father to the son, if gift is made by one legal heir to another, if the gift is made by one spouse to another, in that case acceptance is not required, because if one heir is transferring the property to the another one, in that case of course acceptance is not required. Third essential, that is delivery of possession. Once it is declared, the property must be transferred. That transfer can be actual delivery or constructive delivery, or it can be symbolic delivery. Actual delivery means actually transferring the property. Symbolic delivery means like keys are transferred, documents are transferred. In constructive delivery, actually donee is in possession of the property. For example, watch is repaired by a person, X person. He is actually repairing the watch. Donor declares that the person who is repairing the watch is is donee, that he is transferring, he is gifting the property. So when owner declares that the donee, that is the person who is repairing, will be possessing the property right now, and he will be the owner of the property. So donee is already in possession of property. The mere declaration made by the donor is sufficient. That is constructive delivery. So delivery by the donor is very important part of a hiba, and taking possession of that property. Donee must take possession of that part of a property. That is also important part of hiba. So possession, the delivery of a property can be made of movable property or immovable property. In case of movable property, we can actually transfer, but in case of immovable property, we can transfer documents. We can transfer keys of the flat. So two formalities are mentioned, that donor must depart from the premises and donee must enter into the possession. This is the formality, that is departure by the donor and entry by the donee. This is the formality mentioned for immovable property. But this rule is not applicable when it is gift made by father to the child, or if donor and donee, they are residing in the same territory, in the same property, in the same premises, or it is made by the spouse, one spouse to the another, or if both are co-sharer in the same property, or part delivery is made and part is remaining, or last one, that is of constructive delivery, that donee in possession of property. So this is exception, these are some exception in the formality. So in this video, we have discussed about definition of hiba and essentials of hiba. In the next part of a video, we will be discussing about types of hiba, that is gift of musha as well as other different kinds of musha. Thank you.